My ex-mother-in-law spent 6 years telling everyone I was the reason we had no kids. At the hospital, she bragged about her son's new baby. She didn't know I'd just seen his medical file. She found me near the maternity ward. I had been at Mercy General for 40 minutes, visiting a colleague who had delivered 2 days earlier, navigating the particular sensory landscape of a maternity floor, the soft overhead lighting, the wheeled bassinet carts, the nurses moving with the practiced calm of people who have witnessed the full range of human experience and kept their voices at the same measured volume through all of it. I was at the elevator when I heard her. Carol Bishop, my former mother-in-law, 63 years old, 5'4", pearls she wore to everything including casual Saturday errands, the kind of woman who had weaponized graciousness so thoroughly over so many decades that most people in our town could no longer distinguish it from actual warmth. She was with 2 women I recognized from her church, the same church where, for 6 years, she had deployed her signature line about me with the regularity and the gentle authority of someone reading scripture. She saw me, she smiled, and she said it loud enough for the nurses at the station 8 feet away to hear every word. Leaving you was the best decision my son ever made. Now he has a beautiful baby boy with your best friend. She tilted her head, the practiced tilt, the one that performed sadness while delivering damage. You must be devastated. 6 years of being called the broken one. 6 years of absorbing a wound that had been crafted specifically for me, fitted to the exact dimensions of what I had wanted most and couldn't have. 6 years of watching a town nod along to a story about my body that had been told by people who knew it wasn't true, packed into a single breath, in a hospital hallway, with witnesses. I looked at her. I felt my pulse in a single steady line. I thought about Ruth Calloway's office, about a single sheet of paper slid across a desk, about a diagnosis written in clinical language that had rearranged everything I thought I understood about 6 years of my life. I said, "Is that what you believe?" She blinked. The tilt held, but something behind it shifted, the slight recalibration of a woman who had expected tears or silence and received neither. "It's what everyone knows," she said. "Interesting," I said. I pressed the elevator button. The doors opened. 5 minutes later, standing in the lobby waiting for my car, I saw a man come through the main entrance. Tall, dark coat, the particular focused expression of someone who had just received a piece of information and was still organizing it. Daniel Mercer. He walked past me without seeing me, toward the elevators, toward the maternity floor. I thought about Paige's text from 3 weeks ago. Please don't do this. Think about the baby. I thought about a courtroom date 7 days away. I pressed my keys in my hand and felt the metal against my palm and stood there in the lobby of Mercy General, while something very large and very quiet completed itself. Then I walked to my car. Let me tell you what Carol Bishop had been saying about me, and for how long, before I tell you what happened in that courtroom. I am a nurse practitioner. I have been practicing for 11 years, the last 7 at Mercy General's family medicine clinic. And before that, during the 4 years I was married to Mark Bishop, I worked at the same clinic, building the same patient relationships, earning the same performance reviews. I am, professionally, exactly what my credentials say I am. Personally, in the town of Grover Falls, I had been something else for a long time. Mark and I married when I was 28. He was 31, an insurance adjuster, steady and familiar in the way that men from small towns can be steady and familiar. You grow up seeing them at certain places. You understand them before you know them. The relationship has a shape before it starts. His mother had the particular quality of being everywhere in his life while never appearing to impose on it, which I had initially found impressive and eventually understood was the entire mechanism. We tried to start a family for 3 years. Nothing happened. I went to my OBGYN, Dr. Patricia Crane, 16 years in practice, meticulous, the kind of physician who explained everything twice and kept excellent notes. And I asked for a full fertility workup. The results came back completely normal across every measure: ovarian reserve, hormone levels, uterine structure. Dr. Crane reviewed the results with me in detail. There was nothing to explain why conception wasn't occurring. The standard next step was for Mark to be tested. He refused, not once, 3 times, over 14 months, as I raised it in different ways, with different framings, with different degrees of directness. The 3rd time he said, "It's not me, and I'm not going to sit in some clinic being treated like a problem when the problem is yours to figure out." He said it with the particular certainty of a man who had decided what the truth was, and was not interested in evidence that might complicate it. I went back to Dr. Crane. I told her Mark wouldn't test. She said, in the careful professional language of someone who understood the situation clearly and could not say so directly, "Then you don't have complete information yet." I filed that in the part of my mind where I filed things I couldn't act on yet but needed to remember. Within a month, Carol's line had started circulating. Some women just aren't built for it. She said it the way she said grace. Automatic, practiced, the delivery of something believed so long it no longer needed thinking. She said it at church events, at the PTA meetings she attended with her daughter-in-law at the school where she volunteered, at the book club where 3 of the members were women I worked with at the clinic. I know the reach of it because I felt the reach of it, the promotions I didn't receive, the administrator position that opened up 18 months into Carol's campaign and went to a colleague with comparable qualifications and a name that wasn't carrying Carol's annotation, the specific way a town of 4,000 reorganizes its understanding of you when a credible source, a church woman, a respected mother, has told them what you are. I documented all of it because I am a nurse practitioner. I chart. I note dates, times, specific language. language. I had a folder in my laptop labeled with Carol's name that I added to every time something reached me, and I had been adding to it for 4 years before Mark announced he was leaving me for my best friend Paige and I filed for divorce. And suddenly, the wound that had been theoretical became the only thing I could feel. Paige Mercer, my best friend since college, 14 years of friendship through every version of each of our lives, the person I called first for everything. She had been at my wedding. She had sat with me through every month of the trying and the not happening, and she had held my hand and said the right things, and the entire time she had been sleeping with my husband. I found out when Mark told me, not apologetically, just factually, the way he said most things. I've been seeing Paige for about 8 months, and I think it's serious, and I think we should separate, like a business conversation, like a meeting he'd prepared for. I had stood in our kitchen and looked at the coffee maker and thought, with a clarity that should probably have scared me, I have a folder on my laptop, and I'm going to need a lawyer. Ruth Calloway had been practicing civil litigation in Columbus for 22 years. She had a reputation in her field that came from a specific thing. She was extraordinarily patient with cases that other attorneys considered too slow or too complicated to build correctly, and she was right about them more often than the other attorneys. She had a corner office with a wall of case files organized by color, and when she looked at my folder, printed, dated, organized, she read it front to back without speaking. Then she said 2 words, sue them. She said it with the particular calm of a woman who has seen enough evidence to know what it means. Defamation, specifically, a false statement of fact, published to third parties, causing measurable harm. Your lost promotion, that's quantifiable. The salary differential over 4 years, quantifiable. We have dates, we have witnesses, we have a pattern of distribution. She looked at me. The question is how they respond. They'll say it was true, I said, that the infertility was mine. Yes, Ruth said, and the moment they do that under oath, they've opened the door to every piece of medical evidence in this marriage, including his. She paused. Does Mark have records? He refused to be tested while we were married, I said. Ruth was quiet for a moment. People who refuse to be tested usually have a reason, she said. I looked at the wall of files. There was a day, I said, about 4 years into the marriage. He went to the city alone, said it was a work thing. He came home quiet, poured a drink before dinner without saying anything. I asked if everything was okay, and he said the doctor was a quack. Ruth wrote something in her notepad. Why did you remember that? She asked. Because the whispers started that week, I said. Carol's line, some women just aren't built for it. It started within days of that trip. Ruth put her pen down. File the defamation claim, she said. Let them respond. If they argue the statement was medically accurate, we file a motion to compel his fertility records. Will the court grant it? If they've put his fertility on the table by arguing it as a defense? Yes. She looked at me steadily. Medical privacy protections are significant, but you can't invoke medical privacy to shield evidence you've already put in dispute. I drove home. I sat in my apartment, the one I'd moved to after the divorce, on the second floor of a Victorian building with good windows that I had been slowly making mine, and I looked at the wall I'd been painting one shelf at a time for 8 months, and I thought about Ruth's patience and the color-coded files, and I thought about Mark coming home from a city he didn't name, and pouring a drink without speaking. I called Ruth the next morning. File it, I said. They responded exactly as Ruth had predicted. Mark's attorney, a man named Philip Garrett, 14 years in civil defense, the kind of lawyer who was very good at making plaintiffs feel unreasonable, filed a response to the defamation complaint arguing that Carol's statement could not constitute defamation because it was substantially true. Quick pause. If you want more stories like this in better quality, my Spotify's linked in the description. That the infertility in the marriage had been medically attributable to the plaintiff, that Carol had simply been repeating what she understood to be fact. Ruth read me the response over the phone. They just put his fertility on the table, she said. I know, I said. I'm filing the motion to compel tomorrow, she said. Philip will fight it. He'll fight it hard. Pay attention to how hard he fights it because that tells you something. Philip Garrett fought the motion to compel Mark's fertility records for 6 weeks. He filed 3 separate objections: medical privacy, relevance, proportionality. The judge, a woman named Honorable Sandra Chu, who had been on the bench for 14 years and who reviewed all 3 objections in a hearing that lasted 40 minutes, denied all 3. Defendant's own legal response placed the question of fertility attribution squarely in dispute, she said. Plaintiff is entitled to the records. The records arrived 8 days later. Ruth called me at 4:15 p.m. on a Thursday. She asked me to come in. I drove to Columbus. I sat across from her desk. She slid a single sheet of paper across to me. A clinical report from a fertility clinic in Columbus, dated 7 years earlier. The patient name was Mark Allen Bishop. The diagnosis was azoospermia, the complete absence of measurable sperm in a semen analysis. The report noted the finding was consistent across 2 separate analyses conducted 6 weeks apart. The attending physician's note read, patient was counseled regarding diagnosis and implications for biological fatherhood. Patient expressed significant distress and declined referral for further evaluation or treatment at this time. I read it twice. Then I put it down on Ruth's desk and looked at the window. 7 years ago, he had gone to that clinic. He had been told. He had come home and poured a drink and called the doctor a quack, and within days, Carol had begun her campaign about the woman who wasn't built for children. He had known the entire time. He had handed me the wound and watched me carry it for 6 years in a town where everyone heard about it. I sat in Ruth's office for a long time. Elena, Ruth said. She only used my first name when something was happening outside the legal frame. Are you okay? I thought about that question carefully. I've been better, I said, but I've also been worse. I looked at the report. What does this mean for the case? It means the defense's entire argument collapses, she said. They argued the statement was true. The record says it wasn't. She paused. But there's another question. I looked at her. A man with this diagnosis, she said carefully, cannot father a biological child, which means the baby in the maternity ward isn't his, I said. The word landed in the room and stayed there. That same night, at 9:47 p.m., my phone lit up with a text from a number I recognized. Paige, Elena, please, don't do this. I know what you found. Please think about the baby. Think about what this does to everyone. I held the phone for a long time. A woman who had taken my husband, my best friend, and my reputation was asking me to stop digging because she knew what was in the ground. I typed back, "The hearing is in 7 days. I'll see you there." Then I put my phone face down and went to sleep because I had learned in the past year that the decisions that matter most are made better rested. Before the hearing, I need to tell you about Daniel Mercer. Daniel was Paige's husband, her actual husband for 11 years, until Paige had told him 8 months ago that she had been having an affair and was pregnant, and the baby was Mark's, and she wanted a divorce. Daniel had moved out, hired a lawyer, and been told by Paige's attorney that paternity was established and he had no claim. I had not spoken to Daniel since the divorce. We had been acquaintances the way spouses of close friends are acquaintances, connected through the center point of a friendship that no longer existed. But I knew through mutual contacts that he had been quietly devastated, that he had loved Paige in the uncomplicated way of someone who hadn't known they needed to be paying closer attention. Ruth had found him, not to involve him in the case. The defamation suit was mine, about my reputation, my lost income, my 6 years. But Ruth had a contact in family law, a woman named Jess Okafor, who handled paternity proceedings. And Jess had made a phone call, and Daniel had, as Ruth put it, become aware of information relevant to his own situation. He had filed a motion for paternity testing in a separate proceeding. That proceeding was ongoing. He was at the courthouse on the morning of my hearing because his attorney had a scheduling conflict, and the family court had offered him a different time. I did not know this until I saw him in the hallway outside the civil courtroom. He looked at me. I looked at him. I didn't know, he said. It was not an accusation. It was a statement of fact, said by a man who was still organizing the information. I didn't either, I said. Not until 8 days ago. He nodded. Ruth told me the diagnosis, he said. About Mark. Yes, I said. He looked at the courtroom door. If it's not Mark's, he said, then it might be. Yes, I said again. He was quiet for a moment. I have a son, he said. The words came out slowly, like he was testing their weight. You might, I said. That's what the testing is for. He nodded again. Then he went to find his seat. The courtroom was full. This is the thing about small towns and public hearings. They draw. Carol's church women filled 3 rows. I recognized people from the clinic, from the neighborhood, from the years of parties and potlucks where Carol's line had traveled. Grover Falls had been told a story about me for 6 years. They had come, I think, to see how it ended. Ruth was methodical. She always was. She laid the case in sequence. The statements, dates, locations, witnesses, the specific language Carol had used, and the third parties who had heard it. The promotion I had been passed over for. She entered the HR documentation, the internal emails discussing the decision, the salary differential over 4 years. Real numbers. $47,000 in lost compensation, conservatively calculated. Then she turned to the defense. The defendant responded to this complaint by arguing the statement was medically true, Ruth said. She held up the defense filing, under oath that the infertility in the marriage was attributable to the plaintiff, medically, definitively. She set the defense filing down. She picked up the clinical report. This is the fertility evaluation of Mark Allen Bishop, obtained through court-ordered disclosure after the defense placed the question of fertility attribution in legal dispute. She read the diagnosis aloud. Clinical language, flat, precise, the kind of language that does not leave room for interpretation. Azoospermia, complete absence of measurable sperm, consistent across 2 analyses, dated 7 years ago. She set the report on the plaintiff's table. The statement that the infertility was attributable to my client was not true, she said. It was never true, and the people who made it, in some cases, knew it was not true when they made it. Mark's attorney was on his feet. Your Honor, the defendant was not medically aware. The patient was counseled regarding diagnosis and implications for biological fatherhood, Ruth said, reading from the report. That's the attending physician's note. Patient was counseled, he was told. Mark stood up from the defense table. His suit was slightly too tight across the shoulders, the suit of a man who had bought it at a different size and not updated it. You can't use that here, that's private. You put it in dispute when you filed your response, Judge Chu said, without looking up from her notes. Sit down, Mr. Bishop. He sat. Carol was in the second row, rigid as a woman who has just understood that the floor is moving. She had come, I think, to witness my humiliation. She had dressed for it, the good pearls, the church blazer. She rose from her seat. Some women just aren't built for it, she said, pointing across the courtroom at me, in the voice she had used at every potluck for 6 years, the voice of someone reciting something true and settled. Some women just aren't. She stopped, because the room had gone quiet in the specific way rooms go quiet when something is about to be said that can't be unsaid. I stood up. You're right, Carol. Flat, clear. The voice I use when I have to tell a family something true and hard in a patient room. The voice that holds steady because the person in front of you needs the truth to be steady. One person in that marriage was never built to have children. I looked at Mark. The file only ever had his name on it. The church women turned to look at Carol. Carol. I watched it happen. The row turning, the recalculation visible on faces that had been nodding along to her line for 6 years. Carol's hand dropped. Mark put his face in his hands, and the gesture was so complete and so total that it communicated everything the courtroom needed to understand. And then, from the back row, quietly, Daniel Mercer stood up. He had been there for his own scheduling matter and had stayed for mine, sitting in the back row where I had not seen him come in. He stood up and walked toward the side door, not looking at anyone, moving with the particular focused forward motion of a man who had just understood something that required immediate action. Following Paige, who was in the corridor outside, with a question a courtroom had just provided the grounds to finally answer. The judgment came 3 weeks later. Judge Sandra Chu found in favor of the plaintiff on all counts. Defamation, proven. Quantifiable harm, proven. The salary differential, the lost promotion, the documented spread of a specific false statement through a specific community. The judgment figure was $61,400 in compensatory damages and an additional amount in fees. Ruth had also moved for an injunctive order requiring Carol Bishop to cease making or repeating the specific statement about my fertility. This was granted. Mark's attorney filed a notice of intent to appeal. Ruth sent me an email. Let them. We'll win again. I printed the judgment and put it in the folder I had been keeping for 4 years with Carol's name on it. Then I closed the folder. I don't need to add to it anymore. Daniel Mercer's paternity proceeding concluded 6 weeks after the hearing. The genetic testing confirmed what the mathematics of Mark's diagnosis had already made clear. Daniel is the father. He has a son, 8 pounds, 4 ounces, born on a Thursday in March. I know this because Jess Okafor, Ruth's contact in family law, told Ruth, who told me, not as gossip, as information relevant to the complete picture of what had happened. I have not spoken to Paige. I don't know that I will. There is a version of this story where I feel something uncomplicated about her. Rage or grief or the clean satisfaction of exposure. What I actually feel is more complicated and less satisfying, which is that I lost a friendship I thought was real, and I am still figuring out what to do with the space it left. I see Carol occasionally, in the grocery store or across the parking lot, the way you see people in towns of 4,000. She does not say the line anymore. The injunction is part of that. But I think something else is also part of it. The specific silence of a woman who has seen her certainty examined in a courtroom and found wanting. Mark has not contacted me. 1 year later, I am still at Mercy General. I was offered the administrator position again, a different opening, a different committee, and this time I accepted it. Dr. Crane wrote my recommendation. She used the word exceptional twice and the word thorough once, which from Patricia Crane is essentially a standing ovation. I have the folder still, the one with Carol's name on it. It's in my filing cabinet between a utilities folder and a tax year. I keep it because it is a record of something that was real, and real things deserve to be documented. I went to the maternity floor last month, not for Carol, not for any of this. For a colleague who had delivered, the same colleague I had been visiting the day Carol found me in that hallway. I stood at the elevator, in the same spot. I thought about standing there a year ago, about Carol's pearls and the practice tilt, and leaving you was the best decision my son ever made. I thought about saying, is that what you believe? And I thought about the thing I knew in that moment that she didn't. The single sheet of paper, the clinical language, the man who had been counseled regarding his diagnosis and had gone home and poured a drink and handed the wound to me instead. The file only ever had his name on it. I pressed the elevator button. I had carried their lie for 6 years in a town where everyone heard it. They had confessed to it in the one room where the truth has a permanent address. The elevator doors opened. I stepped in.